rise.
Please be seated. The first case for oral argument this morning is in the matter of Cynthia E. Kiley. Ms. Kiley is present. And once again, Mr. Johnson, you're the best. We very much appreciate your taking time to come from the West Coast to represent Ms. Kiley. And I speak on behalf of each member of the court to give you our highest regards. Disciplinary counsel is present, Ms. Seymour and Ms. Cagiola. Ms. Seymour, you may proceed.
May it please the court, for the record, I'm Barbara Seymour here on behalf of the Disciplinary Council. Formal charges were filed in this disciplinary matter alleging litigation misconduct against the respondent, including the assertion of meritless claims in a number of civil lawsuits in which she was the plaintiff, unreasonably delaying that litigation, lack of candor to the courts in those cases, knowing failure to obey obligations under court rules, and other conduct that is prejudicial to the administration of justice. A default was entered against the respondent after she failed to file an answer to the formal charges, and a hearing was held to make a sanction recommendation. The panel considered evidence in both aggravation and mitigation of sanction, and as a result recommends disbarment of the respondent and an order of restitution in the amount set forth in the court sanctions, the 3 court sanctions orders, and the cost of the proceedings, and ODC concurs with that recommendation. The respondent has taken exception to the recommendation of the panel, raising a number of issues that are not properly before the court, either because of the default or because they weren't properly raised at the hearing. Disciplinary counsel has addressed those exceptions in its brief, and I'm happy to discuss those with the court, but it's our position that there are only 2 matters that are legitimately before the court today: whether or not the default was proper and what the disciplinary sanction should be, if any. With regard to the default, the record is clear that the formal charges were served on the respondent on August the 11th of 2012, making her response pursuant to the rules for disciplinary enforcement due on September the 10th. That date was relayed to the respondent repeatedly by the disciplinary counsel and the panel. A scheduling order that was issued on February the 4th of 2013, a time at which the respondent had yet to answer. The panel chairman ordered that her answer be filed by February the 25th of 2013. And in spite of filing 33 motions, petitions, and appeals between the time the formal charges were filed and the date of the hearing in August of 2013, that's approximately 1 filing every week and a half for 58 weeks. The respondent still filed no answer. This is in spite of giving 5 additional months to do so from the hearing panel. She was certainly capable of filing an answer and has asserted not only no good cause for failing to do so, but no cause whatsoever or explanation for her failure to file an answer. So the default was certainly proper. As a result of that default, the formal charges against her were deemed admitted. And that brings us to the second issue, which is what is the appropriate sanction in this matter. Giving due consideration to the aggravating factors, disbarment is certainly appropriate. The panel was particularly concerned about the respondent's conduct in repeating the very same behavior that brought her here to begin with in response to the disciplinary charges. They addressed in their report her deliberate attempts to obstruct the disciplinary process by blatantly disregarding court rules and panel directives. And this is illustrated by the 31 motions, petitions, and appeals. In addition to the 33 I mentioned before, there were 31 additional filings by the respondent in just the year since the hearing was held. Most of those consist of improper attempts to address the allegations that are deemed admitted by the respondent's default. This is the same deliberate manipulation and abuse of the court process that has caused the unnecessary and protracted litigation with the hospital and the law firm that resulted in $340,000 worth of sanctions orders from 3 judges. But not only that, multiple orders from those judges, from the Court of Appeals, and from this court restricting the respondent's ability to file pro se pleadings and motions. In my experience, that's an extraordinary action on the part of the court, and it's only issued in the most egregious cases of litigation misconduct. And here we have 5 courts who have had to do that. If that's not sufficient to warrant disbarment, I urge the court to consider the respondent's complete and utter lack of acknowledgement of the wrongfulness of her conduct. Even in the face of these adverse rulings from the court and from the panel, even facing the most harsh of sanctions that you can impose, the respondent's conduct persists to this day. You can sense when you read the orders from Judge Dennis and Judge Houston and Judge Harrington their utter exasperation, not knowing what to do to stop the respondent's conduct. Even this court, in connection with filings that she's made in these proceedings, you've admonished her repeatedly, insisting that she comply with your court rules, and yet she persists in failing to do so. The panel's recommendation of disbarment, restitution, and cost is supported by clear and convincing evidence.
Ms. Seymour, I've got a couple of questions. I certainly understand the argument that is made about the admission by default and the arguments you've made about the conduct during the pendency of the matter before the commission and before this court. And I understand the arguments about the sanction, because default and the sanction are matters that would need to be explored even in the face of an alleged default. But one other thing that might survive that I'd like to get your reaction to is the claim by Ms. Colley that you should have been disqualified from pursuing the matter on behalf of the commission because of breaches in confidentiality. And let me see if I understand factually where that was. It revolves around, as I understand it, the faxing of material to Ms. Colley at her medical office. I have looked at the entire bale of papers that constitutes this case and the materials that have been put on disk, so I have scrutinized every piece of this record. And what seems to be the case is that the fax number that you all used to fax something to Ms. Colley had, prior to that time, been used by Ms. Colley to fax material to y'all. And that's what I want to get clear. What, from your point of view, and of course I'm going to ask Mr. Johnson the same thing, but from your point of view, is that a correct recitation of the sequence of events in the record?
It is, but just to clarify a little bit further, this happened in March of 2012. I became involved in the case in January, notified the respondent that we were submitting the matter to the hearing, to the investigative panel in March. In a couple of weeks, and I'm sorry I don't know the exact dates, I didn't prepare the dates, but in a couple of weeks leading up to that hearing, we received more than a dozen faxes from from the respondent. These letters were difficult to decipher, but they contain things like, "This confirms our agreement for a continuance in the matter when no such agreement ever occurred." These consisted of requests to submit additional documentation, which had been provided to her.
I understand there were 2 points in time that I looked at. One is a series of faxes back and forth that were in the 2012 category, and there are faxes from Ms. Kiley that begin this fax exchange that have the printed, as of course that's what happens when you fax. The machine prints over the top the origin of the fax.
That's right.
And the origin of the faxes from Ms. Kiley is her fax at her medical office.
That's
then
right.
You send things back. Then you flash forward to a time much later on, right before the matter was heard, as I recall it. It was in the summer sometime, when, again, Ms. Kiley is faxing you, and she's got this tape over the top of it that indicates the fax number, and she's got, in some of them, a handwritten fax number in addition to what is printed over the top, and then you respond to that fax.
Okay, I only faxed her one time, and that was in 2012 prior to the filing of formal charges. Mm-hmm. And we used the only fax number that we had, and the only reason that I did that was because it was a matter of some urgency. She was not responding to the voicemail messages I was leaving, and I didn't have time to get her a letter. To ensure confidentiality, and yes, we did use the fax number that she was using to fax to us. She had no email that we could contact her with. The fax cover letter has the word confidential, I think about 19 or 20 times on it. I also contacted her by voicemail to let her know that the fax was coming, and her voicemail was full, so I couldn't give her that information. I have not sent her any other faxes, but that's not because I think that we breached her confidentiality. We absolutely did not do that.
Now,
and I just want to point out that allegation has been fully investigated by the investigative panel in response to the grievance, one of the grievances she filed against me. She raised it again with the panel hearing chairman. He denied it and determined there was no wrongdoing. She's raised it repeatedly in motions to disqualify me before this court, and those motions have been denied.
Right, and then just kind of completing the loop on the way contact is made, I even noticed that there are some faxes later on that come from the Holiday Inn Express on her behalf or some other kind of commercial business thing. But in addition to that, the court had directed that Ms. Kiley establish a email account pursuant to the rules of the Attorney Information System. And a representation was made on her behalf at one of these arguments that would be done. But the email address that is supplied is not checked by her, as I understand it.
That's what I understand from the automatic reply that continues to come back from that email. Any emails that we've sent to the court for administrative matters in the scheduling of this, we've copied to her, and we get the response, that same response back that was referenced in the interim suspension order.
Questions from other members of the court?
Ms. Seymour, has ODC ever sought a mental evaluation of the respondent in this case?
We have not.
I don't have anything further.
Questions from other members of the court? Very well. Thank you, Ms. Seymour.
Thank you.
Mr. Johnson?
Thank you, Your Honor. My name is Chalmers Johnson. I'm here representing the respondent, Cynthia Colley.
Gained a little weight since the last time we saw you.
Yes, Your Honor, I have. Thanks for noticing.
So camera. Have we all.
And it had to be on camera, too. Your Honors, I haven't been part of this case until very recently. I picked it up and tried to look at it with a fresh eye and see what the issues were I could bring before you. And if you'll give me a moment, I'll bring you into how I think this is relevant and why I can argue this before you. I'm here to challenge the constitutionality of the South Carolina Frivolous Proceeding Sanctions Act. Now, the way that I think we get to this, and the reason I think I can stand up here and make this argument, one of the bases for the sanction is Rule of Professional Conduct 3.4c. A lawyer shall not knowingly disobey an obligation under the rules of a tribunal except for an open refusal based on an assertion that no valid obligation exists. One of the things that the disciplinary counsel mentioned that is an issue here is whether the default was correct or not. And in this case, Dr. Holmes has openly refused to answer the formal charges. And the reason that she's openly refused to answer the formal charges is that she has consistently argued that the Frivolous Proceeding Sanctions Act is unconstitutional.
Well, let me ask you this. If the Frivolous Civil Procedure Act is unconstitutional, and that is interposed as a defense, why was not that interposed by way of answer? I mean, that's the box we are in. Sometimes you can waive constitutional rights as well as all kinds of rights by not interposing that as your defense. And she never answered and interposed that. Nor did she, in the process of the litigation in which she was sanctioned, ever interpose that. So we're kind of in a double bind. The pleadings allege the violation that you have referred to, but we don't have anything that interposes that.
I understand.
That doesn't mean I'm saying don't argue it and everything. You're doing what you're supposed to do, but from a procedural standpoint, how do we get over that mountain?
Well, I understand, Your Honor. And one of the things, as you know, I've been working with Ms. Colley for quite some time on many cases. One of the things that's plagued her when she was not represented by counsel, as with the ODC, is that she's educated as a lawyer. She's licensed as a lawyer. She took the bar, but she is inexperienced as an attorney. An experienced attorney probably would have known that you should answer and not waive any of your defenses. Somebody who is educated in the law and could read the law, as Ms. Colley, would probably feel that to answer was to concede that there was some viability to the claim in the first place.
Does that in some way bespeak an unfitness to practice law?
The fact that she's inexperienced, Your Honor?
The fact that she's inexperienced, the fact she hadn't had a client in 30 years, the fact that, this accumulation of what has been deemed by judges in the past as vexatious conduct and all that kind of thing, does that not all accumulate and result in a apt conclusion that she lacks fitness to practice law under Rule 7.5?
Your Honor, honestly, if we're talking about, let's begin with lack of experience. If lack of experience is a basis to find that an attorney is unfit to practice law, that any graduate out of law school should be deemed unfit to practice law because they're inexperienced. Lawyers come out of law school and we are not taught how to practice. We are taught how to read law.
Mr. Chalmers, you're
Yes, Your Honor.
telling us, you're arguing that somehow we should excuse her for not filing an answer because she didn't apparently understand that when a complaint is filed, you have to file an answer if you dispute it. I mean, that's pretty basic, isn't it? I do think most first-year lawyers know that.
Perhaps, Your Honor. But I understand the position she was coming from because, if I'm able to continue my argument, her argument in the beginning is that the only report that has caused this entire disciplinary council investigation was a report that was authorized by a statute or required by a statute that is unconstitutional.
Mr. Johnson, if I could ask you, and it's sort of before you get too far along, it's as a nexus to what Justice Hearn asked. And the most recent thing I studied in the case was the supplemental citations submitted by the respondent, I think toward the latter part of September. And there was a sentence in there that deals with what you're speaking about, sir. It says the lawyer respondent was deprived of the right to submit a response to
Yes,
the
sir.
investigative panel. So was it a choice on her part not to, or was for some external sources was she deprived or prevented
Thank you, Your Honor.
Filing a response.
That's where I'm going with this. The initial report, and it wasn't a complaint, it was a report by Judge Dennis, was filed in September 18th or 19th of 2009, 5 years ago. And Judge Dennis clearly reported, you can see it in the transcript, because he felt that he was obligated to under the statute, not because he was making a complaint as a judge concerned about a lawyer. During the proceedings, when we got to the formal complaint, there's a transcript of January 31st, 2013, where Ms. Seymour is quoted saying, "It is not just the frivolous lawsuits and motions that she filed that give rise to the formal charges in this matter." And this is when they're trying to decide what the formal charges are that she needs to answer. And Ms. Seymour says, "There's a myriad of other allegations against her with regard to the way she handled those cases, as well as some additional action that she took against the lawyers who were opposing counsel in those actions." At that point, Ms. Seymour is basically alleging that there are other complaints besides the report that Judge Dennis alleged. Later, the ODC issued a scheduling order, and they required by February 15, 2013, that the ODC respond to any request for information that Ms. Colley made. Her request for information was to give her the complaints that had been made besides Judge Dennis's report, which she felt was being under an unconstitutional statute. The time passed, and no further complaints were ever made. Typically...
I don't guess I am fully understanding this argument, Mr. Johnson. Quite often, a complaint will be made, and it will result in an investigation of a lawyer's conduct. And that investigation may reveal other things. Then there isn't some subsequent complaint that comes in, but whatever is revealed by the investigation of ODC is then placed before the investigatory panel, and they make the decision based on what is placed before them as to whether to initiate a formal complaint. And the formal complaint is then initiated, and that formal complaint in this case cited everything they were talking about. And that is the document to which she needed to reply and knew she needed to reply, asked for extensions, was given extensions, then had a final scheduling order after a scheduling conference, which she knew about, participated in, where a date was set for the final response. So how was she prevented from responding?
Understood, Your Honor. What we're alleging she was prevented from responding to is these anonymous other complaints.
There wasn't any anonymous other complaints as that would have triggered anything. What is triggered in terms of what she has to respond to, and all that the ODC can pursue when they, if it's authorized by the investigatory panel, is what is in that formal complaint. And the issues we're dealing with here are not some anonymous issues. They are whatever is in this complaint she did not answer. That is all that's before this court. That's all we're looking at, and that is all that she had to respond to. And what I'm asking is, how was she prevented from responding to the allegations of the formal complaint?
She was not. She chose not to respond to the allegations of the formal complaint on purpose. What she was trying to determine...
And misguided, I think you would agree completely, because you waive your rights if you don't respond. The rules are quite clear about that.
Correct, Your Honor. And what's in the formal complaint basically just parrots the orders that were given by the court.
Right, and that's what we hear about is her pursuit of frivolous litigation, and that issue was covered not just in one judge's order, Judge Dennis's, but in Judge Houston and Judge Harrington's order. That is the reason for the sanctions contained in each of those three orders, was the bringing of frivolous litigation and the pursuit of vexatious conduct in connection with it.
I understand, Your Honor.
And she's admitted to that by failing to respond.
Well, Your Honor, there is no response to the citation of the orders. The orders say what they say. They've been appealed.
That's not correct at all. Some orders don't result in anything more than just you got to comply with. In this case, those orders were the basis of a complaint against her for unprofessional conduct.
Yes.
And they are the evidence of the unprofessional conduct. So yes, she had to reply to that. She did not.
Understood, Your Honor. You've led me right back to where I want to be, which is that the only reason that the ODC investigation began in the first place at all was because of a reporting requirement of an unconstitutional statute. Had Judge Dennis not made that initial report, we wouldn't be here today.
Well, I mean, how does that help her?
Because I don't think the ODC has jurisdiction to investigate unless they have a complaint. They don't go out and just pick lawyers and start investigating or pick up an order.
That is how they, from a judge's point of view, that is exactly how they pursue things. A judge places a report before them. You mixing apples and oranges. A complaint in terms that deal with what we deal with is the formal complaint. The ODC gets matters from many different sources, but the complaint, and they ask a lawyer to respond, which Ms. Kiley did not, and then if they feel it's warranted, they ask the investigatory panel to give them the authority to bring a formal complaint. That's the complaint that's at issue here.
Yes, Your Honor.
She's not replying to Judge Dennis. She is replying to a recitation that her conduct in these pieces of litigation was unprofessional and violated the canons of professional conduct.
I understand that, Your Honor.
Yet your thesis is all she was admitting is that the content of these orders, which found her to be bringing frivolous lawsuits or whatever, and that there is nothing that she could say to counter the existence of those orders. Is that what you're saying here?
Yes, Your Honor.
That's all it is. And are you saying that in your judgment, a lawyer cannot be sanctioned for the bringing of frivolous lawsuits through the disciplinary process?
I wouldn't say that, Your Honor.
Okay, well, explain to me how we got 4 lawsuits, I think, 3 or 4 in here. At least 2 of them she's represented by counsel, right?
Correct, Your Honor.
And 2 of them she's pro se, and I think that some of those orders say that we're not saying we're doing anything about her conduct as a lawyer, but as a litigant. Am I right on that? Somewhere in that, somewhere contained in some of these orders that find her to be acting frivolously?
Some of them sanction her as a party. Some of them sanction her as an attorney under Rule 11.
Yeah. And hopping ahead, in terms of the sanction that is sought, disbarment, obviously you disagree with that we shouldn't even get to a sanction, that there should be no finding of misconduct. But if we did, you would clearly challenge the sanction. And what about what is called restitution? The $200,000, the $90,000, the $53,000. That's a bit different from, for instance, bilking a client, is it not?
Very different, Your Honor.
And is there not a procedure through which those to whom these sums are owed can obtain those sums separate and distinct from the disciplinary process? Yes,
Your Honor. In fact, she's been ordered through those orders, which have been appealed to this court and affirmed, that she has to pay those sums. So any order from the disciplinary counselor based on this request from the panel is completely redundant and unnecessary. It wouldn't achieve anything, honestly. The request for disbarment, I think, would also achieve nothing. The whole point of the disciplinary counsel when an attorney is up for disbarment is to protect the public from that attorney, and specifically to protect the public from representation by that attorney. Attorneys stand in a special role of trust with their clients. And I know that the panel said that it is completely irrelevant that she was pro se the entire time, and it's completely irrelevant that she's never represented a client in 30 years and probably never will. They say that as long as she has a license, she might one day pick up her license and go start representing clients, and that's who they're trying to protect. Your Honors, I believe that if they have to find clear and convincing evidence that there's a need to protect the public, they have not presented that. They've presented some speculation that is in fact the opposite of what the evidence is. Your Honor, as I'm out of time.
May I ask a question?
Yes, of course.
Oh, you go
Justice
first,
Kittredge?
I'm
No,
sorry.
go right ahead.
Let me preface my question by going back to Ms. Seymour's argument, and perhaps I'm oversimplifying it and generalizing too much. But as ODC sort of paints with a broad brush, they're conveying to this court to look at respondent's conduct in the context of this ODC matter, just as if she acted in the underlying credentialing litigation. And that is, it was like water torture, drip, 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 one frivolous motion, filing, one after another, and making these accusations. One of the things that I've read in the supplemental citations submitted by respondent concerns me, and I just want to see if there's anything to this that you can point to anything in the record. It's on page 5 of the supplemental citation, and the respondent states, the record reflects abundant evidence of altered, incomplete, and or forged record on behalf of the state. Can you, I mean, that's a very serious allegation. And can you point to me to any example of any altered or forged document by ODC in this matter?
Your Honor, I know that Ms. Colley had hired an expert who determined that a document appeared to be a forgery. I haven't looked into it further than that. If Your Honor would give me a moment, I'll discuss it with Ms. Colley and get you an answer.
Well, maybe I could direct that to her, because I think the court will give an opportunity for her to respond if I'm not overstepping my bounds on that, Chief.
Exactly. As I understand it, it revolves around whether the court received a certain document, the name of Angie, and I can't remember her last name. This is what that all revolves around. I have never gotten straight in my mind what we're talking about in terms of the forging of a document. When you ask, are we talking about the date it was received by the Court of Appeals, or what are we, or by the ODC? It's very confusing.
I'm sorry, Your Honor, I didn't focus on that detail when I prepared today.
All right. You might take a moment to consult with her before that question is asked and it answered, and it can be answered either by you or by Ms. Colley. And let me say that in all these kinds of proceedings, we always give respondent a chance to be heard. She does not have to be heard. It's not required. But if she desires to address the court, we'll be glad to hear from her. If she prefers for you to answer that question and not to address the court about anything, then that's okay. It doesn't count against her. It's not a negative of any kind. So if you would consult with Ms. Colley about that, we would appreciate it.
I will, Your Honor. Thank you.
Your Honor, excuse me, Chief, before he does that, may I ask a question?
Certainly, certainly.
It's my understanding from this voluminous record and these incidents that have taken place over the years that some of these actions that are complained of by ODC were actually taken by representing counsel. Is that correct?
By me, yes, Your Honor.
Not necessarily by you, but other counsel involved in some of the other cases. Is that
Perhaps,
correct?
yes, sir.
Now, those same allegations form the basis of the complaints against her today. Is that correct?
I believe so.
Now, are any of those lawyers who represented her, have they been charged with anything?
Not a one, Your Honor. And on top of that, the word frivolous has been thrown around quite a bit as to motions being filed. Over and over and over, we see allegations that this frivolous motion, that frivolous motion, none of them were found to be frivolous. The appeals court never found any of her appeals to be frivolous. They were either untimely or interlocutory, and the appeals court is asked to find them frivolous if they are. So it's not true that she filed frivolous motions. She filed a lot of motions, and she was incorrect on a lot of her motions. But nobody's ever found them to be frivolous, and I believe, again, what she suffers most from is an education in the law and not so much experience. She was doing the best she could to pursue her own case pro se. She also happens to be a lawyer. That's why she's here
Are you
today.
suggesting then that we should view the situation differently because she happens to be a lawyer, but she was proceeding pro se?
Yes, Your Honor, and there's a very good reason for that. We all know that it's a bad idea to represent yourself, and the reason for that is you can't get an emotional distance from the case. If you represent yourself, you tend to focus on the case from an emotional standpoint, and you'll do anything you can to win the case. I believe that if Ms. Colley was actually representing a client and was able to have the emotional distance that attorneys are supposed to have professionally, she would have acted differently. Ms. Colley is upset. She feels very strongly about what has happened in this litigation. You can tell. Win or lose, she feels strongly about it. Even two of the judges, I think Judge Dennis and Judge Houston, in their orders say that they can tell that that Ms. Colley believes in her case.
Particularly Judge Houston's order.
Very much.
Very sensitive.
And of course, Mr. Johnson, if you go back and all this is repeated one more time in the brief she filed, or the exceptions, whatever you would term it, this all goes back to her disagreement with the initial resolution of this case to begin with. She ultimately settled her complaint against East Cooper for several $100,000. She then refused to sign the settlement document for quite some time. She was finally ordered by the court, and she did sign it. And then she attempted to revive this litigation again and again and again. And basically, the courts that looked at that determined that this was an attempt to revive something that had already been settled by litigation in a settlement agreement she signed. She tried to characterize in her later litigation the credentialing issue as something that arose post the settlement. But every document that's been filed in those various lawsuits, and I've read every page of them, always goes back to 1997 and to the beginning of the squabble that she had with East Cooper, and the feeling on her part that there was a conspiracy against her by the doctors that handled credentialing and were the practitioners and were the other ophthalmologists and so forth and so on. That, and it's from the standpoint of what she's filed, as if that settlement never existed. So that's the point at which I have a hard time understanding that she's doing something that's legitimate. It's not frivolous. It's been found to be frivolous several different times since, and several different judges have found, and she hasn't been successful on appeal, and this court has found, and the Court of Appeal has found, that she is pursuing something that already was disposed of and that she can't pursue any longer. Isn't that correct?
Your Honor, may I respectfully respond and disagree that, and of course, my petition for rehearing on this very issue was denied. And
exactly. At some point, litigation comes to an end.
It does.
And those matters are beyond being able to be continually relitigated.
And Your Honor, the continuous litigation that occurred after the settlement was an attempt to enforce the settlement agreement, which was drafted by the defense.
It wasn't styled that way at all, Mr. Johnson. It was styled as an additional new cause of action.
Right.
There's never been anything in those pleadings that styled it as an attempt to enforce an agreed-upon settlement.
It was you're right, Your Honor, it was a new lawsuit alleging a breach of the settlement agreement rather than an action upon the old settlement agreement to bring it back in front of the judge.
And
so,
time and time again, several judges before whom this was pursued before it came to this court found that however it was characterized, because of what the settlement itself said, there was no breach of the settlement, and these matters could not be then further pursued.
The claims were about her attempts to get credentialing after the settlement. And
I understand that, but she related back the reason that they were not going to credential her and put her on full-time status to what had happened before.
Right,
and, you know, that was all grappled with and dealt with, and a decision's been made a long time ago, several different times, that those lawsuits could not be pursued.
her allegation, Your Honor, was that they held a grudge and they didn't want her at that hospital.
I understand all that, but, you know, that she never won on that.
Understood. Yes, Your Honor, I was here.
All right, now, if you would consult with Ms. Colley.
I will, Your Honor. Thank you very much.
Mr. Johnson?
Your Honor, here's the information I was able to glean. There is, Ms. Colley says there were 3 separate documents that were all supposedly the same affidavit of service. She can't remember what document they were an affidavit of service for. And she alleges that there was one that was sent to her, there was one in the commission record, and that there was one in the record, and they are different. She also tells me that she sent a proffer.
The affidavits are different?
Correct, the affidavit of service. She tells me that she entered into the proffered record in this case, and I don't have it in front of me, Your Honor, an expert affidavit stating that he'd reviewed the signatures and they were set in different documents.
She did, no question about that. She entered an affidavit from a gentleman in Texas, I think, who was a handwriting expert.
Correct.
What I could not tell from looking at the materials we were supplied with is what we were talking about. You know, the record's quite chopped up, and what I saw was there's this handwriting expert's opinion, and then attached to it is 3 different signatures of Angie somebody or another. I can't remember whether it's Jones or whatever, but anyway, there's a signature, 3 different signatures. But the documents themselves, the affidavits, are not there to tell you that one is different from another. There's a affidavit of service, and then there are these 3 different signatures. So it's very hard for, at least it was for me, to try to figure out what are we talking about here.
Your Honor, I just asked her if she could tell me what document it was that the affidavit of service was purporting to serve.
At least we're zeroed in on what she's talking about, and I'll certainly take a look at it again and see if I can make it out. And obviously, if further clarity can be supplied, we'll be happy to have you submit something to us afterwards, further clarifying the position on that and pointing us to the document that's being discussed.
Thank you, Your Honor. I'll be happy to do that.
Absolutely. Now, would Ms. Colley care to address the court? Yes. Very good. Mr. Clerk, come around and swear Ms. Colley, please.
You swear the testimony you shall give in the case now and here shall be truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Your Honors, thank you all for hearing this contentious matter today. By way of introduction, I worked just as hard as any other physician in medical school, in intensive internship, and rigorous residency. I have the same constitutional rights as any other physician to earn a livelihood for support and education of dependent children. I have the same constitutional rights as any other physician to defend those rights, to seek legal redress for wrongdoing causing harm, and to seek full and fair hearing at trial by jury. Those rights have been wrongfully denied. But for the unconstitutional retroactive application of the Revised Frivolous Proceedings Act, we would not be here. The Revised Frivolous Proceedings Act, or the FPA, is unconstitutional on its face and as applied, as set forth more fully in our brief. With your permission, improper request or improper inclusion in a default order of relief that was not requested in notice is characteristic of the way that Deputy Disciplinary Counsel has proceeded in this case. In summary, I wish or would like that the court find the FPA is unconstitutional on its face as applied, and there is no clear and convincing evidence of wrongdoing. Thank you, Your Honors. Thank you all.
Thank you, Ms. Kiley. All right. Ms. Seymour, in reply.
Thank you. First, I need to address the allegation of forgery against me. I find myself in the unfortunate situation of having to defend against allegations of misconduct in this context. I can tell you exactly the basis for those false allegations if you'd like me to explain
yes,
further.
Yes, how about clarify that for us?
It may shortcut some of the supplemental filings that I anticipate being filed after this hearing. At some point, in an attempt to avoid the requirement of filing an answer, Ms. Kiley alleged that the certificate of service of the formal charges was a forgery. She presumed that that forgery was me forging the signature of our administrative assistant, Angie Stevens. She submitted strips of paper bearing Ms. Stevens' signature to a so-called expert in Texas who came back with an affidavit in which he decided which of those signatures was legitimate and which ones are forgeries. All of those signatures were Ms. Stevens' signatures. The certificate of service that she claims was altered. The only copy of that we've ever seen is a copy produced by her in an attempt to avoid answering the formal charges and distracting the commission in this court from the charges against her and to focus on my conduct. The only explanation that we have, and we have thoroughly reviewed our files and the commission's files, the only explanation that we have for the certificate of service that she claims to be a forgery is that it is one fabricated by her. These allegations were made against me in the second grievance that she filed against me. They were fully investigated by the investigative panel who reviewed all of the documents pertinent to it and my response to that, and those allegations were dismissed. In spite of all of that, she had the opportunity to present this evidence at the hearing. Even if she's going to couch it in terms of mitigation of sanction, she had the opportunity to do that at the hearing so that this court would have a full record, albeit over our objections that we most certainly would have made. But this court would have had a full opportunity to review that record and make a determination as to whether or not that was relevant in this case. She failed to do it, and we don't believe that she should be permitted to once again submit those false allegations in an attempt to avoid discipline. Having said that, I wanted to address her allegation that we are seeking relief that was not requested in the formal charges. Not exactly sure what it is she's referring to in that context, but if you refer to page 13 and 14 of the formal charges, we requested a sanction, we requested cost, and we requested any sanction pursuant to Rule 7B. The panel elected to recommend disbarment, cost, and restitution. And I would like to address the restitution, and I'm almost out of my time.
Help me with that, because, restitution implies restoring something. And I think this is quite different from having bilked a client or stolen money from a client. There are mechanisms for these folks to whom these amounts are due to get them separate and apart from the disciplinary process. And my concern is, I'm not suggesting this, but there is a concern that the disciplinary process may be used somewhat as a collection agency for this kind of thing. So help me with that.
I certainly understand the distinction, and I would first point out that the parties who have those sanction orders entered in their favor did not file the grievance, so there was no attempt on their part. But I understand the risk that...
There's never been a complaint, has there?
Well, can I address that one in just a minute after I tell you why restitution is necessary in this particular case?
Yes, ma'am.
Because I certainly agree with you that ordinarily simply imposing discipline to enforce an underlying court order in most circumstances would not be an appropriate thing to do.
Yes.
I think it's absolutely necessary in this case for two reasons. One, she's demonstrated that she has no intention of paying those. Second, in order for these parties to go back and try and collect this money that they're entitled to under this order means additional civil proceedings. And that means that they're going to get wrapped right back up into all of these motions and petitions and appeals and challenges to those initial orders. The fact that they are here today continuing to reassert the same legal arguments that have been shot down time and time again indicates to me that that is going to continue to happen if these parties attempt to enforce these orders.
Seymour, what makes the parties that these sanctions are owed to, these funds are owed to, what makes them any different from any other creditor? Why can't they pursue another means of collecting this money?
They can.
Why should we get involved in that through a disciplinary action?
The reason, and again, the reason that you should do that is for the protection of the public, because she's not going to pay it on her own. These orders don't mean anything to her.
So we should then disbar any lawyer out there that owes anyone some money then?
Absolutely not. Absolutely not. And
we've got a specific thing with court reporters. That's different. But this, Justice Beatty's question is, to me, thought-provoking. When somebody is sanctioned for conduct or whatever by a judge, and it's reduced to a judgment, which it is, I'm still having some difficulty with it. And let me forgive me for interrupting you. You had a train of thought going, and I interrupted.
That's okay, but I do want to make sure that you understand that there's a distinction between the recommendation of disbarment and the recommendation of restitution. There's nothing that indicates that we are seeking or the panel is recommending disbarment because she owes people money. Those two things don't have. That is absolutely not the argument that we're making, and I think my argument is clear that the reason why we think that in this particular case that it is appropriate for a disciplinary order to pay those, even if you disagree with the recommendation of payment of restitution, if you're not buying that argument, disbarment is still appropriate.
I understand the two are separate and distinct. The sanction with regard to whether it's disbarment or some lesser punishment or sanction is distinct from the question of what has been termed by ODC as restitution. I understand the distinction between the two, and that one does not depend upon the other, or the one does not depend upon this one over here. So.
And of course, ODC and the hearing panel, this is the recommendation of the hearing panel, but just to give you an example of why we think that's appropriate, why we are confident that these parties are going to continue to be subjected to this litigation. There was reference to by Justice Kittredge to the supplemental citations that were submitted by the respondent. This court issued an order allowing her to submit this supplemental citation, which she did last week, completely contrary to the rules because it contains significant argument, which is not permitted. But on page 2 of the supplemental citations at the end of the second paragraph, the respondent says, because case number 2010 CP10 3410 is currently pending in Charleston County for trial by jury, that case is not final, and therefore jurisdiction under the revised Frivolous Proceedings Act is lacking. I know this is outside the record, but she's brought it up. They have gone back to the 2010 litigation in which Judge Harrington issued a summary judgment order. It has been fully vetted on appeal. That summary judgment order has been upheld, and they are still filing motions in that case. It is still her belief that that is an active case and that she's going to get a jury trial. The chances of these orders ever being enforced without another 10 or 15 years of litigation are just slim to none. Let me go back to the point about whether or not the disciplinary proceedings are appropriate in the first place. And the respondent has focused from the very beginning on the fact, this connection between the application of what she believes to be an unconstitutional statute to the legitimacy of this investigation. If Judge Dennis had never sent in his order, would we still be here today? My guess is we probably would, but that's pure speculation whether we would or we wouldn't. The fact of the matter is he did send it in. He was perfectly within his rights to do that, regardless of whether a statute required it or not. And as the Chief Justice mentioned, a grievance is information from any source. And wherever that leads in the normal course of the investigation, and in this particular case, led to the issuance of Judge Houston's order and all of the conduct in connection with that litigation, the issuance of Judge Harrington's order and all of the misconduct that occurred in connection with that litigation, and then the misconduct that occurred in connection with the disciplinary investigation.
Let me ask you this, Ms. Seymour. The constitutionality or not of the FPA, Federal Proceedings Act. Let's say it's unconstitutional. What effect, if any, does it have on this proceeding?
Absolutely none. Okay. There were legitimate and reasonable ways for anybody to challenge the constitutionality of that act in proper procedures under the rules of civil procedure, and her conduct went far beyond that. She has not been charged anywhere in these formal charges with violations of that act. The orders of the court are simply evidence of her misconduct in violation of the rules of professional conduct.
And her primary linchpin is between the Frivolous Proceedings Act and these proceedings is the fact that but for Judge Dennis's report, this never would have happened.
Right.
And that goes back to your argument you made a moment ago.
That's exactly right, yes.
To get it clear in my mind, we're here about sanctions. And as I understand it, the allegations against her are partly based upon actions taken by counsel who represented her. Is that correct?
That is correct.
Now, have you all pursued counsel in those cases that represented her in these frivolous activities?
I apologize, but I don't feel comfortable answering a question that's confidential in that regard.
I understand.
I'm happy to submit something under seal in that regard. But I can tell you that even if you take out all of the litigation or all of the conduct where she was represented by counsel and consider that not to be misconduct, there's still sufficient evidence in this record of her.
If you were to back those out, what allegations would be left?
The allegations still remain that she was representing herself in connection with really 2.5 of these lawsuits, because there was a point at which in one of the lawsuits that counsel was discharged and she continued pro se. So even if you just take her pro se filings and the orders related to her pro se filings, it's sufficient to support that.
Even if you just take the litigation in front of Judge Houston, which was entirely pro se, and the trial and so forth and so on, what I understand you to be saying is there's plenty of substantiation for the Commission's bringing of a formal complaint and the resolution of the Commission.
That's right. And I also just want to make one more point, and could I just have one more minute, with regard to whether or not you should sanction a lawyer for her conduct as a pro se litigant, whether you should impose the standards of professional conduct for lawyers on a lawyer who's acting in her own behalf. This court has not particularly specifically addressed that issue, although there have been a number of cases where the court has imposed sanctions on lawyers for their conduct in connection with representing themselves in their own litigation. The Edwards case was a case where a lawyer was sanctioned for his conduct in connection with his own domestic matter. Yarborough was a case where a lawyer was sanctioned in connection with his own criminal matter. And I apologize for not having those citations. I'm happy to supplement on that issue.
We're very familiar with those cases.
But I would just like to read from the preamble to the Rules of Professional Conduct. It says, a lawyer is a public citizen having special responsibility for the quality of justice. A lawyer's conduct should conform to the requirements of the law, both in professional service to clients and in the lawyer's business and personal affairs. A lawyer should use the law's procedures only for legitimate purposes and not to harass or intimidate others. While it's a lawyer's duty when necessary to challenge the rectitude of official action, it's also a lawyer's duty to uphold legal process. And her challenging the constitutionality of this statute is not why we're here today. There was nothing inappropriate about that. It was the means by which she chose to do that.
One last question, if I may be permitted, Madam Chief Justice. Can we extrapolate from all of the matters that are before us a finding of a lack of competence to practice law and thus impose a sanction based on these allegations and in your judgment?
In my judgment, you absolutely can, because there are only two possibilities for what's caused this misconduct. One is an inability to comprehend the basic rules of procedure, the inability to do that, or a deliberate and intentional failure to comply with those rules. Under either scenario, I believe that disbarment is warranted.
We understand Mr. Johnson's counterpoint to that of inexperience and that kind of thing, so I just wanted to get your take on that. Thank you.
Thank you, Ms. Seymour. Court will be in recess.